The Subcommittee on Workplace Protections will come to order. I note that a quorum is present. Without objection, the chair is authorized to call a recess at any time. During the current administration, OSHA quickly established a reputation for pushing a regulatory agenda that is at odds with the interests of small businesses, workers, and the overall health of the American economy. For instance, as the nation and the private sector were healing from the COVID-19 pandemic, OSHA proposed a vast, sweeping, and illegal COVID-19 vaccine mandate. Despite a sharp rebuke from the Supreme Court, OSHA has refused to change its ways. The purpose of today's hearing is to encourage a more thoughtful and balanced approach to rulemaking, one marked by fact-finding, evidence, and humility rather than overreach and ideology. On the one hand, we see a problem with overreach, like the walk-around rule and the emergency response proposed standard. While the country faces a shortage of firefighters and EMS workers, this one-size-fits-all proposed rule mandates massive administrative burdens and costs that will worsen existing challenges in recruiting and retaining emergency responders. The walk-around rule allows third parties to accompany OSHA inspectors on workplace safety inspection tours. Workplace safety inspections should never become a pretext for some other agenda, regardless of whether you support or oppose that agenda. The proposed rule cheapens the protections that exist in current law, and American workers will suffer as a result. Yet even as OSHA produces many regulations that go beyond its mandate and do more harm than good, it has failed to actually carry out its mission and produce rules where needed. For instance, we see an absence of rulemaking when it comes to the tree care industry, despite the industry long asking for a standard. The tree care industry remains one of the most hazardous industries in the nation as a result of this negligence. OSHA must act to protect tree care workers and provide regulatory consistency. This is all happening, of course, under the longest-serving acting Secretary of Labor in U.S. history. Despite failing to garner the votes needed to be confirmed to be Secretary of Labor, Julie Su continues to unlawfully serve in that role. Su has been serving in her position unconfirmed for an astounding 499 days, far surpassing any other unconfirmed secretary. Americans deserve a confirmed United States Secretary of Labor, not one who the Senate has rejected on a bipartisan basis. OSHA should acknowledge and implement feedback from workers and job creators when writing its regulations to ensure its policies are workable in the real world. Any regulation handed down by a federal agency should be narrowly focused, and compliance should be realistic. Overburdensome regulations hurt the workers they're meant to protect. Today, we'll hear from industry experts who will be able to speak about some of OSHA's other regulations and how they're affecting them. With that, I look forward to the insights of our witnesses today in this subcommittee hearing, and I yield to the ranking member for an opening statement.
Thank you, Mr. Chairman, and thank you to our witnesses for your testimony today, and welcome. This hearing is particularly timely as next week is the 20th anniversary of the passing of the Ascension Valdivia, who died in his son's car on the way to a hospital after he collapsed in the field during a 10-hour shift of grape picking in a triple-digit heat. However, 20 years later, our constituents still lack the basic common sense protections that would keep them from safe heat stress and extreme temperatures. In North Carolina, the family of Wednesday Johnson continues to mourn the loss of their mother, sister, and aunt. Ms. Johnson served her community for 20 years as a postal worker, yet lost her life shortly after hours of working in an unair-conditioned postal truck in 90-degree weather. We're not talking about being uncomfortable on a hot day. We're talking about excessive heat combined with heavy clothing and high humidity that can incapacitate our body's natural cooling mechanisms and lead to injury, organ failure, and death. And this problem is only getting worse. In fact, this past Sunday was the hottest day ever recorded on Earth. Thankfully, after years of advocacy, the Occupational Safety and Health Administration, OSHA, under the leadership of President Biden and Vice President Harris, has proposed common sense measures that employers can take to prevent these tragedies. Contrary to my colleagues' rantings about skewed priorities, OSHA absolutely is pursuing the priorities that will benefit American workers and their employers. Research shows that prevention pays. For example, OSHA's cotton dust rule saved lives and reduced the rates of brown lung. The textile industry argued at the time that the rule would bankrupt them, but instead it incentivized employers to discover more efficient ways of doing business. In fact, there's much more work that OSHA should be doing to protect workers. In this testimony, Mr. Gershenberger highlights the need for a tree care standard, and I do agree that such a standard is necessary. But what I do not understand is how cutting OSHA's budget will do anything to expedite that process. Year after year, House Republicans work to cut OSHA's budget and reduce its regulatory capacity, and then have the nerve to complain that the agency isn't effective. Well, the challenge is not that OSHA's priorities are skewed, but rather it has been that Congress's failure to adequately support an agency whose sole mission is to keep workers safe on the job. And as we speak, House Republican appropriators are advocating to slash OSHA's budget by roughly 12%. I've met countless constituents with horrifying stories about heat illness in the workplace and employers who won't even provide them with cool water. To slash OSHA's budget and to attack the proposed heat standard is to say that the health and the lives of my constituents do not matter. The reality is, this Congress, House Republicans have abandoned their commitment to workers as evidenced by their proposed agenda, Project 2025. If my Republican colleagues had their way and enacted Project 2025, businesses would get a pass for any non-willful violation if it was the first time they were caught. And that would mean that an employer could commit any number of OSHA violations, even a serious violation in which a worker is killed, and no one would be held accountable. Aside from the pain and the suffering caused by not adequately protecting workers, the economy suffers as well when we do not take a proactive approach to addressing hazardous workplaces. As our witness, Mr. Barb, mentions in his testimony, a 2020 report found that the loss of labor because of heat exposure cost the economy about $100 billion, a figure projected to grow to $500 billion annually by 2050. Workers should not have to risk their lives and safety to provide for themselves and their families. Committee Democrats are committed to ensuring that OSHA has the resources and the capacity to ensure workers come home safely at the end of the day. And that's why I introduced with Ranking Member Scott the Protecting Children Act, to address abusive child labor by providing OSHA with the resources to deter violations and prevent harm to children from intensive work in dangerous jobs. And it's why I co-sponsored the Assunção Valdez Heat Illness, Injury, and Fatality Prevention Act to ensure swift action on an OSHA standard that will provide workers the support from heat stress, and why I support Representative Courtney's and Ranking Member Scott's Protecting America's Working Act, which provides OSHA with the tools to enforce worker safety and to hold employers accountable. Ultimately, if committee Republicans continue to turn a blind eye to employer workplace violations, then workers will keep sustaining serious work-related injuries, or worse, face a preventable death. With that, I look forward to a productive discussion today, and Mr. Chairman, I yield back. Thank you.
Pursuant to Committee Rule 8C, all committee members who wish to insert written statements into the record may do so by submitting them to the committee clerk electronically in Microsoft Word format by 5 p.m. after 14 days from the date of this hearing, which is August 7th, 2024. And without objection, the hearing record will remain open for 14 days after the date of this hearing to allow such statements and other extraneous material referenced during the hearing to be submitted for the official hearing record. I note for the subcommittee that some of my colleagues who are not permanent members of this subcommittee may be waiving on for the purpose of today's hearing. I'll now turn to the introduction of our distinguished witnesses. Our first witness today is Chief Tim Bradley, who is the director of the North Carolina National Volunteer Fire Council, which is located in Mebane, North Carolina. Our second witness is Ms. Felicia Watson, who is senior counsel at Littler Mendelson in Washington, D.C. Our third witness is Mr. Jordan Barub, who is a former Deputy Assistant Secretary of OSHA and is in Tacoma Park, Maryland. And our final witness is Mr. Peter Gerstenberger, who is the Senior Vice President for Industry Support of the Tree Care Industry Association, located in Manchester, New Hampshire. We thank the witnesses for being here today and look forward to your testimony. Pursuant to committee rules, I would ask that you each limit your oral presentation to a 5-minute summary of your written statement. I would like to remind the witnesses to be aware of their responsibility to provide accurate information to the subcommittee. I will first recognize Chief Bradley.
Good morning, Chairman Kiley, Ranking Member Adams, and distinguished members of the subcommittee. My name is Tim Bradley, and I'm a firefighter with 50 years of experience and a director of the National Volunteer Fire Council. I'm also Deputy Chief of the Mebane Fire Department and the Executive Director of the North Carolina State Firefighters Association. The NVFC, National Volunteer Fire Council, is a leading nonprofit membership association representing the interests of volunteer fire, EMS, and rescue services. We serve as the national voice for over 676,000 volunteer firefighters, which comprise 65% of the nation's fire service. The National Volunteer Fire Council appreciates OSHA's efforts to promote our mutual goal of ensuring firefighter safety in this proposed emergency response standard. However, if adopted as written, this standard would be economically infeasible for volunteer fire departments to comply with and could cause some of those fire departments to close down, therefore compromising the emergency response capabilities of many small communities, particularly those in rural areas. In addition to its economic infeasibility, this proposed standard would be problematic due to the incorporation by reference of industry standards, uncertainty about volunteer coverage, lack of personal expertise and availability to facilitate implementation, and an unrealistic proposed timeline for implementation. For these reasons, the National Volunteer Fire Council believes OSHA should exempt volunteer firefighters from this proposed standard as written. The National Volunteer Fire Council is concerned that OSHA is unaware of the varied ways volunteer fire departments are organized and therefore unaware of the extent the proposed standard would impact the volunteer fire service, especially when it comes to how volunteer fire departments are organized as nonprofit organizations and unaffiliated with any municipality, meaning they could fall within the scope of this proposed standard regardless of the state that they are in. Due to the diverse nature of the volunteer fire service, the NVFC believes it should not fall within the scope of OSHA's proposed rules. When it comes to evaluating the economic feasibility of OSHA's proposed standard, it is important to realize that 95% of volunteer firefighters serve a community of less than 25,000, and 50% serve populations of fewer than 2,500. National needs assessments for the nation's fire service consistently show that volunteer fire departments in small and rural communities have the most difficulty affording up-to-date equipment. In an NVFC departmental budget survey with 2,444 responses, 29% said their department's budget is less than $75,000. Departments with this budget struggle to pay for fuel, supplies, and gear and equipment, with the average cost of equipping a single firefighter with bunker gear at $4,600. OSHA estimates the average cost of their proposed standard to be approximately $14,000 per volunteer fire department. The NVFC believes this estimate is low, and it would be much greater. It is economically infeasible to have small departments adhere to the same standard as large departments like New York City. The main source of federal support to support these local fire department funding is Assistance Firefighter Grants, AFG, and Staffing for Adequate Fire and Emergency Response, SAFER. Though AFG and SAFER grants have been very successful, there is not enough funding available to address the needs of the fire service, especially if there is an added economic burden of OSHA standard. Contributing to this economic infeasibility are numerous prohibitive requirements that are contained within the proposed emergency response standard, including the incorporation by reference of over 20 National Fire Protection Association, NFPA, and American National Standards Institute, ANSI, industry consensus standards. The incorporation of these standards by reference would pose several issues, one being that these standards are not updated on a 3 to 5 year cycle like NFPA standards are. Another issue is the lack of access to these standards. NFPA standards are available online to review, but printing copies must be purchased. This limited access to these NFPA standards is problematic since many volunteer fire departments in rural areas lack reliable internet services. Additionally, some of the education requirements in these standards incorporated by reference are not available in states. For example, Fire Officer 3 referenced in NFPA 1021 is only available in 20 states. The NVFC thanks the subcommittee for holding this important hearing and for the opportunity to testify on the need for the volunteer fire service to be exempt from OSHA's proposed emergency response standard as written. We also thank Chairwoman Fox and Chairman Kiley for their leadership on this issue.
Thank you very much. I will next recognize Ms. Watson.
Thank you, Chairman Kiley, Ranking Member Adams, members of the subcommittee. Good morning, and thank you for the opportunity to appear before you today. My name is Felicia Watson. I'm a senior counsel in the law firm Littler Mendelsohn. My testimony this morning is solely on behalf of myself and not my firm or any of its clients. I'm here today because we all have a common goal: increase employer and employee compliance with the Occupational Safety and Health Act. This includes safeguarding the ability of employers and employees to work and thrive in their chosen professions, and ensuring employers are able to protect their workers while at the same time ensuring employees are able to work in places that are safe and free from recognized hazards. I have three considerations for this subcommittee related to OSHA's rulemaking efforts on heat. First, the rulemaking process has become perfunctory, even though the agency has been formally engaged on a proposed heat standard since 2021. OSHA first published an advance notice of proposed rulemaking in that year, convened a small business advocacy review, held meetings with small entity representatives, held meetings with the Advisory Committee on Construction Safety and Health, and other groups to discuss its proposal. Although at the time no one had seen what the actual proposal was, they'd had these meetings to discuss. Then on June 11th of this year, the proposed rule went to OIRA. OIRA had the 1,175-page proposed rule for approximately 14 business days before sending it back to OSHA on July 1st. My concern over the speed with which OIRA cleared the proposed rule is whether the agency, OIRA, was able to effectively meet its oversight obligations in 14 days. I repeat, 1,175 pages. It's still not in the Federal Register. Given that the proposed standard will affect more than 36 million businesses at least, the administration has missed an opportunity to collect vital input from stakeholders before making the proposed regulation public. OSHA has also missed or ignored an opportunity to develop industry-specific standards that would help it more effectively meet its goals. Numerous effective businesses ask for industry-specific standards that can be used to better comply, but this did not happen. Second, OSHA's approach will in effect force employers into the role of parents who have to treat employees like children that need someone to take care of them. Employers and employees both have duties under the OSHA Act. Unlike under other safety standards such as fall protection, which have a direct correlation if an employee is not given proper equipment to prevent falls, heat-related illnesses and injuries are not always straightforward or obvious. This is a nuanced issue that is more complicated than it first appears, with myriad factors that can affect how someone may respond to heat. Certain signs and symptoms of heat-related illness can be the same for other illnesses such as the flu or COVID-19. Personal risk factors also come into the analysis here. Underlying health issues, personal behaviors when away from the job site, all of these can impact it. Yet the employer will be required to assume that while at work, any symptom is heat-related, and if they do not respond quickly enough, they will face a citation and penalty unless and until it can be established it was not heat-related. But this is only after a citation is issued. The proposed rule contains a number of prescriptive requirements, but one notable one is proper hydration. When temperatures meet a certain heat triggers, employers will have to implement certain procedures, including telling their workers about the importance of drinking water. There's even a proposed amount of drinking water that employees should provide their employer per hour. Third, OSHA missed an opportunity to provide a pathway for employers to be able to clearly understand their obligations. A consistent theme among stakeholders to date was that one size does not fit all. Unfortunately, stakeholders were ignored. Instead, there is one all-encompassing rule applicable to employers regardless of industry type. Ultimately, OSHA has developed a prescriptive rule that, despite the agency's assurances to the contrary, allows little flexibility for employers. Working in hot conditions is not new. OSHA has failed to do a thorough analysis of the options available in order to push this standard through quickly. The cumulative effect of ever-changing requirements, coupled with new regulations going into effect at least annually, can have a huge impact on employers. The unrecognized administrative burden this creates should give pause to those responsible for writing laws and developing regulations. Thank you for the opportunity to appear before you today, discuss the agency's overreach and the impacts the agency's actions have on the regulated community, large and small businesses, employers, and downstream consumers. Thank you.
Thank you very much. I now recognize Mr. Barub.
Thank you, Chairman Kiley and Dr. Adams. Thank you for inviting me to testify. Although I want to start with suggesting that the title of the hearing is in error. It would more accurately be Overcoming Obstacles to Saving Workers' Lives. When Gabriel Infante, a construction worker in San Antonio, Texas, started showing signs of heat stroke, his employer thought he was on drugs. By the time it was clear it was heat illness, it was too late. Gabriel died a few hours later. His body temperature was 109.8 degrees. He was 24 years old. If OSHA's heat standard had been in place, Gabriel Infante would likely be alive today. He would have had time to acclimatize, he would have been supplied with water, shade, and rest. And if he had gotten sick anyway, his employer and coworkers would immediately have recognized the signs of heat stroke and gotten him help. Gabriel Infante's story illustrates that OSHA standards save lives. Far fewer workers are dying today of asbestos-related disease or diseases caused by exposure to lead because of OSHA standards. OSHA standards have significantly reduced deaths in confined spaces and trenches. Work-related hepatitis B has been eliminated since issuance of OSHA's bloodborne pathogen standard, and I could go on and on. A few facts. First, there is no question that OSHA has a legal authority and mandate to issue safety and health standards to protect workers from hazards that pose a significant risk of harm. The very first line of the OSHA Act charges OSHA to assure safe and healthful working conditions for working men and women by authorizing enforcement of the standards developed under the Act. Second, the perennial accusation that OSHA standards threaten businesses or kill jobs is simply a myth. Third, OSHA's regulatory process takes far too long. The last two major last two standards that OSHA issued, silica and beryllium, took almost 20 years. Why the delays? First, the complex standard-setting criteria set in the OSHA Act. Second, subsequent laws, court decisions, and executive orders. Third, OSHA's robust public input process. And fourth, OSHA's paltry budget. And finally, the failure of recent Republican administrations to issue any major regulatory protections. Protections delayed mean lives lost. 12,000 workers died from exposure to silica in the 19 years it took for OSHA to issue the silica standard, and over 1,700 died of beryllium-related disease in the time it took OSHA to issue its beryllium standard. The General Duty Clause is no substitute for standards. It's too resource-intensive and generally used only reactively after a worker is killed or seriously injured. Let's take a look at OSHA's top regulatory priorities. Heat. 121 workers died from the effects of heat from 2017 to 2022, and 384 workers from environmental heat exposure over the last decade. Climate change is making it worse, and it's generally agreed that these numbers are significantly underestimated. The solutions laid out in OSHA's proposal are simple, flexible, inexpensive, desperately needed, and long overdue. Second, infectious diseases. COVID-19, Ebola, avian flu, tuberculosis, measles, MRSA are just a few of the infectious diseases that healthcare workers are not protected from because aside from bloodborne pathogens, there is no infectious disease standard. The danger is obvious. Thousands of frontline healthcare workers died from COVID. Tree care, as Mr. Gerstenberger will testify, too many workers are killed in tree care incidents and a standard is needed. But budget shortages are slowing that process down. Workplace violence, assaults against healthcare workers and social service workers have long been a serious problem, and which OSHA has addressed through guidance and General Duty Clause, but a standard is clearly needed, so much so that this House has twice passed bipartisan legislation that would require OSHA to issue a standard much more quickly than the normal process. Emergency response. Emergency responders face deadly hazard, and the current OSHA standards are antiquated. The equipment described in OSHA's current standards would better fit in a Norman Rockwell painting than a 21st century firehouse. As Chief Bradley testified, there are legitimate concerns about the feasibility for volunteer fire departments. OSHA is listening to those concerns and will decide based on the evidence provided. Let me conclude by with a few recommendations. First, Congress should examine more effective and far speedier standard-setting processes in California and Washington, significantly increase OSHA's budget, pass legislation to update antiquated standards for toxic substances and other hazards, and finally, exempt OSHA from some procedural requirements under the OSHA Act or the Administrative Procedure Act, or authorize OSHA to issue interim final standards where hazards need to be addressed expeditiously. OSHA standards save the lives and protect the health of this nation's workers. They are not overreach. OSHA protections are exactly what Congress ordered. I'd be happy to answer any questions.
Thank you. And our final witness is Mr. Gerstenberger.
Chairman Kiley, Ranking Member Adams, and distinguished members of the subcommittee, thank you for this opportunity to testify. I'm Peter Gerstenberger, the Senior Vice President of Industry Support for TCIA, an association with a central focus on worker safety. I'm here to advocate for a dedicated OSHA standard to protect the lives of tree care workers, and I will note I have testified before this subcommittee twice in the past on this very same topic. TCIA members do vital work and are members of some of the most safety-conscious people in the world, facing some of the greatest workplace hazards imaginable. We estimate about 200,000 workers in this profession and confirmed over 240 fatal incidents in tree care from 2020 through 2023, an average of 60 a year. It means that tree workers experience fatalities at an annual rate at least 10 times higher than BLS's all-industry average for private sector workers. To address these risks, we engage our members through a variety of safety programs the association has created, and we helped establish and actively participate in the ANSI Z133 committee, which develops the only consensus safety standard for tree care operations. We also consistently engage regulators to push for policy changes that can improve safety for workers in our industry. I was fortunate to have helped assemble and to serve on committees to create tree care specific rules in the state plan OSHAs of California, Virginia, and Maryland. TCIA is engaged right now in an alliance with North Carolina OSHA that promises to bring about fair and effective guidance for arborists in that state. We've collaborated with federal OSHA in the past on regulations specific to our members' work around power lines, as well as a variety of basic guidance documents detailing the hazards of tree work created under a formal alliance with federal OSHA. While we appreciate these efforts, we're frustrated by federal OSHA's continuous delays and missed deadlines in establishing a specific standard for our industry. The subcommittee requested OSHA consider doing so in August of 1998, after OSHA began applying standards intended for other industries to our members' work. Over the next decade, OSHA continued this ineffective approach to regulating our industry, and in 2006, TCIA formally petitioned OSHA to promulgate a standard which has received consistent bipartisan bicameral support. While OSHA took initial steps with rulemaking shortly after our petition, it wasn't until 2020 that the agency made tangible progress by completing the required SBREFA panel. This process concluded with a strong recommendation for OSHA to move forward with a tree care standard and provided a clear path for how OSHA should develop a proposed rule. In the meantime, OSHA's Enforcement Directorate has attempted to regulate tree care through a series of memoranda and directives that ultimately failed to provide clear guidance to employers, to workers, and OSHA officers on the most effective safety measures for the industry. Since SBREFA, OSHA has postponed publication of a proposed tree care standard 7 times since it first appeared in the regulatory agenda in 2020. During this same period, the Office of Information and Regulatory Affairs reviewed 10 other distinct OSHA regulations. This selective inaction sends a troubling message that the safety of our workers is not a priority. As OSHA continues to delay a standard, tree care work is becoming increasingly difficult and dangerous due to trees debilitated or killed by drought, disease, invasive insects like emerald ash borer, and wildfire. Therefore, the time to act on a tree care specific standard is now. An industry specific standard will empower OSHA field enforcement to identify unique hazards, preventing accidents and saving lives. Without this standard, the tree care industry remains vulnerable to avoidable hazards, undermining the critical work of these professionals. We'd like to thank Chairman Carley and Ranking Member Adams for joining Senator Hickenlooper and Senator Braun to send a letter in April to OSHA urging the agency to promptly issue a proposed rule for tree care. We urge this subcommittee to ask OSHA, in the strongest possible terms, to move forward on this rulemaking. Thank you again for this opportunity.
Thank you very much. Under Committee Rule 9, we will now question witnesses under the 5-minute rule. I recognize first the gentleman from Wisconsin, Mr. Grothman.
Mr. Barab, I'm going to start with you. As I understand it right now, OSHA will investigate the death of any employee, but there's an exemption for employers of 3 or less employees. Is that correct?
There's a partial exemption for employers that I think between less than 10 employees if their average injury and illness rate is below the average for that industry. It's a rider in the appropriations bill.
Okay. Is there any reason why you can think if an employee dies in a farm with only 3 employees, you shouldn't investigate that death?
No, actually, yeah, in farms, it's any farm under 10 or under, yeah, OSHA is not allowed to set foot on. No, I think that's completely unjustified. Farming is one of the most dangerous occupations there is. Lots of workers are killed in farms, are injured, or would like to file complaints, but OSHA is prohibited from even setting foot, no matter how many people are killed on a small farm.
Okay, thank you. And now we'll go to Ms. Watson on the walk-around rule. The finalized walk-around rule does not include any requirement that the authorized person be equipped or conduct themselves in the same standards as an OSHA safety inspector, because the rule has the potential of allowing anyone on the job site. Construction employers are faced with serious safety concerns. Why does OSHA not provide or mandate specific safety training for non-employer representatives to ensure they don't pose additional safety standards?
I'm sorry, sir, I missed the first part of your question.
Okay, the finalized walk-around rule does not include any requirement that the authorized person be equipped or conduct themselves to the same standards as an OSHA safety inspector, because the rule has the potential of allowing anyone on the job site. Construction employers are faced with serious safety concerns. Why does OSHA not provide or mandate specific safety training for non-employer representatives?
That's a wonderful question for the agency. And that's one of the concerns that a lot of employers I've heard from have expressed. The person that the compliance safety and health officer selects doesn't have to have any specific training to be on the job site. It's just if they will have good cause or lend something to the inspection. And so that is definitely a concern from the employers, is how can they ensure this person's safety if they don't have any specialized training?
Okay, by forcing employers to allow outside parties into their facilities, OSHA creates additional liability risk for employers. At the simplest level, a third-party representative may slip and fall while attending a walk-around. Suddenly, the employer may face a costly lawsuit. How does OSHA intend to protect the interests of employers against the potential that third-party representatives are putting their business at risk?
There are no provisions in the rule to address that. OSHA's focus when they come on a job site is to ensure that the employer is following the rules to ensure worker safety, employee safety. That would actually turn it on its head if there was something in the rule that required OSHA to ensure that employers are protected against liability.
Okay. How can OSHA claim neutrality in collective bargaining disputes under the current rule, you think?
How can they ensure neutrality of collective bargaining?
Yeah.
I don't think that they have a role in that. I think if a job site has an employee representative that's been designated, an employee representative for the most part is a union representative. That's how it's been construed through the years, and that's how it's identified. But I don't think that OSHA has a place to get involved in that. That's not their role.
Okay. An argument is made that third-party representatives would provide context and educate. An argument is made that third-party representatives would provide context and educate on complex workplace issues. However, why don't we just educate the CSHOs on these complex issues, keeping unauthorized third parties away from employers' private property?
I think that that is something that should fall under OSHA, and OSHA should ensure that their compliance, safety, and health officers are well trained. I think the idea behind the walk-around rule initially and the provision in the OSHA Act was to allow someone with specialized experience. This walk-around rule has expanded that well beyond that and reduced the technical requirements for these third-party inspectors. So it does create a problem. Thank you.
Thank you. That's
Thank you. I now recognize the ranking member, Ms. Adams, for 5 minutes.
Thank you, Mr. Chairman. The Project 2025 Roadmap for a new Trump administration was developed by a team with more than 100 former Trump administration officials, which proposes to change the law so that employers will be exempt from any consequences for safety violations if they meet 3 conditions. First, if they're small businesses, then if the violation was not willful, and then if it is the first time that they've been caught. Mr. Barr, when you were the Deputy Assistant Secretary, how often did you speak with families who had lost loved ones to a death on the job? And in those conversations, did you ever hear one of those grieving family members tell you that they wanted to let the employer off the hook just because it was a small business?
Yeah, thank you for the question, Dr. Adams. No, I never heard any worker complain about OSHA, inspecting or citing their employer just because they were a small business. No employee should have to ever worry about coming home alive at the end of the day based on the size of the business he or she work for. Everyone should have the same rights and the same ability to be inspected by OSHA. If small employers, and I understand if small employers have more of a burden, they don't have the money perhaps to hire experts on staff or even to hire consultants. For that reason, though, OSHA has a very robust and fairly well-funded on-site consultation program that essentially gives small employers the opportunity to have an OSHA inspection free of the risk of citation. So essentially, small employers already can be exempted from their first inspection because they can call it themselves out of the consultation program.
Thank you. The Project 2025 scheme would allow small businesses to be held accountable if an OSHA violation was willful. But doesn't that mean that they would still have a get-out-jail-free card for serious violations?
Yeah, that's basically what it means. I mean, if small employers were exempted, and a lot of business, there are a lot of small employers in this country, obviously. They do a lot of dangerous work, and there are a lot of workers in small businesses that are injured, made ill, or killed. And there's no reason why they should be exempted from having the same protections that larger employers have.
So do I understand correctly that a worker could die from a serious OSHA violation, and this Project 2025 policy would allow the employer to get off scot-free?
Yeah, no, there should be no reason for any employer to get off scot-free, and whether that's a small employer or, as Mr. Grothman asked about farm employers, agricultural employers, every employer, and I should say every worker in this country should have the right to a safe workplace. Unfortunately, they're pushing for exemptions in small businesses. Agricultural workers on small farms are exempted. There are 8 million public employees in this country that are also exempted from OSHA coverage, who should, again, have the same right to a safe workplace that every other worker has.
So when you and Dr. Michaels ran OSHA, you rejected calls for a heat standard. So do you still believe that protecting workers from heat stress should not be a priority for OSHA?
I'm sorry, I missed the end of that question.
When you and Dr. Michaels ran OSHA, you rejected calls for a heat standard. Do you still believe that protecting workers from heat stress should not be a priority for OSHA?
No, yes. I mean, I think you're referring. We were petitioned for a heat standard during our administration, and we rejected that petition. That was a very painful step. We always believed that heat should be a priority. Unfortunately, due to OSHA's funding, our pipeline just is not very wide. We were working, putting about 120% of our resources into finishing silica, beryllium, and a number of other standards. We just did not have the bandwidth at that point to handle heat. So we did, unfortunately, reject the petition. We did, however, issue a number of standards at the end of the administration, which, following the Trump administration, OSHA did have the bandwidth then to tackle the heat problem.
So some critics of OSHA propose a rule argue that it's impossible to set a national standard because workers have varying levels of susceptibility to heat. So how would you respond to that?
Well, heat is it's a fairly simple process to protect workers against heat: water, shade, rest. Every worker needs that. The OSHA Act actually requires the agency's standards to ensure that no worker suffers serious physical harm from hazards. So OSHA needs to, protect all workers, no matter what their pre-existing conditions are. And again, it's easy to do: water, shade, rest, having an emergency response program, training that can apply to every worker in every possible occupation.
Thank you very much, and thank you very much. Mr. Chairman, I yield back.
I'll now recognize myself for 5 minutes. Chief Bradley, thank you for your presentation about the proposed emergency rule, which may be a well-intentioned rule. Of course, we want our first responders and firefighters to have the highest level of protection and preparedness. But as you explained in your testimony, it could very well have some severe unintended consequences in terms, for example, of the cost that it imposes on volunteer fire departments. And I think OSHA has put it at a figure of like $14,000. But does that sound realistic to you as to what the actual cost of this will be?
Thank you, Chairman Kyle. No, the $14,000 won't even buy 2 air packs. The average cost of purchasing turnout gear for a firefighter is $4,000. Many volunteer fire departments struggle when they bring on a new member to simply equip them with gear because of that cost. If you figure an estimated budget of $75,000, an air pack costs $9,000, you can see that $14,000 to replace the equipment some of these standards would require is excessive.
Yeah, I think that there's just sort of a lack of understanding by those who drafted this rule about how volunteer firefighters really work. I mean, I have, counties in my district that have a dozen different fire departments. Some of them are in areas that are hard to get to and are largely volunteer driven. And so these departments are carrying a heavy burden for their communities with very few resources. And they are really the first line of defense. I mean, if they're not able to address a situation immediately, it could grow into a much larger problem. And so if this rule goes forward, could you just help us understand what some of the trade-offs might be in terms of the consequences for these volunteer fire departments that are now going to be even more under-resourced?
Thank you. First off, no one's tried harder to reduce firefighter injuries and firefighter deaths than the fire service itself. Many of these volunteer fire departments apply NFPA standards as they can. But if you consider that these local communities have to do their own fundraising for fire departments, sometimes firefighters have to buy their own gear. This added burden may very well close a volunteer fire department in a rural community. If they do that, then the community faces extended travel times from a neighboring area to get fire protection, increased insurance rates because insurance services offices rate areas for homeowners insurance and business insurance based on fire protection. So the unintended consequences of closing fire departments will be critical, especially in rural and suburban communities.
Such an important point that this could well close volunteer fire departments and leave these areas unprotected. I hope that message is heard by our friends at OSHA. Mr. Gerstenberger, what do you think it's going to take for OSHA to finally do a tree care standard? As you mentioned, we've written a bipartisan letter urging them to do so, yet you said they've put it off, 7 times or something like that, even during the current administration? What's it going to take? Why are they dragging their feet?
I'm hopeful, Mr. Chairman, that it will take a strong word from this committee and or reviewing the proceedings of this hearing to prompt further action. I have to think at this point that proposed language is pretty much in place and could be released, and we pursue the process from there. But quite frankly, I'm befuddled by why it's taken 25 years from the time we first raised the issue and 18 years from when we petitioned for it, and why the proposed rule has been delayed in publication 7 times in the past 39 months. I'm completely befuddled by that. And
it is befuddling, and it's also tragic, because you mentioned just over the last 4 years we've had 240 fatalities in the industry. That's 10 times higher than the average rate. Do you believe that some of those lives would have been saved if we had an adequate standard?
Using a very rough estimate, Chairman, Since we petitioned for the standard, we've lost probably in excess of 1,000 people in this industry. One loss is too many, obviously. Could an OSHA rule prevent all of these? Absolutely not. That's just not realistic, but it could have prevented some.
It could have prevented some. We would have saved lives with a standard. And, we've heard some excuses today, like the budget isn't there. Well, the budget has gone up significantly during this administration, hasn't it? And haven't there been, you said, 10 other actions that were taken by OSHA while they neglected to take action here?
I don't have any particular insight as to the adequacy of OSHA's resources, its budget. My association faces budget constraints every year, and I know that what we try to do with limited resources is to make sure we get the most bang for our buck.
That's right.
And I would take a data-driven approach to, how OSHA can get the most bang for its buck. And I would say that producing a standard for a relatively small industry with an incredibly high fatality rate would be a good way of affecting its mission.
Thank you very much. I hope that message is heard loud and clear by OSHA. Let's get this done. It will save lives. I now recognize the representative from California, Mr. Takano.
Well, thank you, Mr. Chairman, and thank you to the witnesses for being here today. Anyone who lives in Washington, D.C. during the past month is well aware of what experts are telling us, that this is the hottest summer ever recorded. I was thankful last week to be in Santa Fe and Colorado Springs, where it was drier and cooler. But according to the National Oceanic and Atmospheric Administration in 2023, was the hottest year on record worldwide. And 2024 is projected to be even hotter. In my district in Southern California, we had 3 wildfires this week alone, and my heart goes out to all of the citizens of my district, and I give praise to the firefighters, the brave firefighters who were involved in controlling those fires. So extreme heat and increasing temperatures are our new collective reality. But for those whose nature of work is defined by constant exposure to the elements, this is truly becoming an issue of life and death. Mr. Barra, can you describe why heat is considered a workplace hazard that necessitates rulemaking?
Yes, thank you for the question, Mr. Takano. There are tens of millions of workers in this country who work outside in hot conditions, construction workers, agricultural workers who have a significantly higher percentage of whom have experienced heat-related illnesses and fatalities, and they're indoor workers. I mean, you're well aware of the the warehouse workers in your district where these warehouses or the containers that they're moving in and out are not air conditioned, can literally be like working in ovens. And this affects workers. Some of these workers are working 8-10 hours a day in these kind of conditions. The human body is just not equipped to deal with that unless you have what OSHA is, proposing to require: enough water and enough shade and enough rest. There are things we can do. I mean, heat is definitely a major problem, a fatal problem, but there are. It's not a puzzle. It's fairly simple. It's well known what to do to protect workers, and OSHA is trying to do that.
Well, thank you. Under the DOL new rule and Acting Secretary Sue's leadership, OSHA emphasizes the obligation of employers to create a safe environment to protect workers. This includes the provision of water and rest break areas, as you mentioned, maintenance of personal protective equipment for heat, and monitoring employees for heat stress. Mr. Barab, could you explain why OSHA prioritizes providing a safe environment rather than controlling individual employee behavior?
Well, first of all, under the Occupational Safety and Health Act, the employer has responsibility for establishing a safe and healthful workplace. That is the employer's responsibility. Employees have very little control over workplace conditions. They can't control how the air conditioning works if they happen to have it. They can't control what the weather is going to be if they're working outside, obviously. These are things, fortunately or unfortunately, depending on the employer, are under the employer's total control. So putting the responsibility on workers to find water. If you're working in the fields and you're working on piece rate, taking time off to go find water, you can't rest unless the employer allows you to rest. And if there's no shade around and the employer hasn't provided shade, there's no shade to get. So it really is these working conditions regarding heat or really any other workplace hazard are up to the employer. They're the employer's responsibility, not the worker's responsibility.
Well, thank you for that answer. While heat causes the most weather-related deaths in the country, on behalf of my constituents, a significant portion of whom work in warehouses, as you mentioned, on construction sites and in orchards and in crop fields, I'm grateful that the Biden administration is fighting for their protection. I want to pivot to warehouse work, which is an important sector of the labor force in my district. Children are currently barred from warehouse work by federal labor rules, child labor rules. A second Trump administration would likely mean a significant reduction in OSHA's authority, and Project 2025 agenda would eliminate this rule along with many others. Mr. Baird, what can you tell us about the health and safety risks in warehouse work?
Yeah, well, there's a lot of dangerous work done in warehouses. Obviously, the lifting, the heat you mentioned, forklifts. There are a number of other potential problems, in warehouses. And there's a number of dangerous jobs that the Wage and Hour Division of the Department of Labor prohibits children from doing. And it's really up to OSHA or Wage and Hour in that case to make sure that children are guarded against those dangerous conditions.
Yeah, well, my time is up.
The representative from Missouri, Mr. Burleson, is recognized for 5 minutes.
Thank you, Mr. Chairman. Ms. Watson, I understand that you represent and counsel employers on occupational safety and health law issues. Regarding the heat rule that we've been discussing, climates are different across the country, and what may be considered extreme in one area is not in another. Does this rule allow for those kind of variances from region to region?
There are no specific regional differences that are carved out in the proposed standard. And for clarification, this still has not been published in the Federal Register, so we're presuming that what is on OSHA's website is what we're reviewing. The concern here is that they do recognize how to deal with heat if there's humidity factors and other things, but there are no specific regional differences. One example I can give you where OSHA looks at it is they've left it up to the employer to decide when the heat season would kick in so that they would have to educate their workers on what the heat protections would be for that season. So there is some flexibility there, but there isn't that true recognition of what's good in Santa Fe, New Mexico is not going to necessarily be good in Virginia, in Northern Virginia or Southern Virginia. There aren't those kind of recognitions, and that's problematic for employers.
Yeah. Then the other rule that has been discussed is the walk-around rule that was published in April, which I think is just remarkable that we now have a situation where the OSHA compliance and safety officer can be escorted or by a union organizer, community activist, or some third party to accompany them in the inspection of another workplace. Is this done in any other aspect, or is this, because this is an entirely new concept to me?
There is a provision in the OSHA Act that does allow a compliance, safety, and health officer, a COSHO, to allow a third-party person who meets certain criteria. But this regulation really expands that. And I think the troubling thing is that it's just the scope and breadth of who might be able to come on the job site. And then the issue for employers certainly is, well, what if there's already a union in place, but another union representative wants to come in? Or and the sole discretion is with the COSHO. It is not with the employer. The employer's only option at that point is to refuse entry and require the compliance, safety, and health officer to go get an administrative warrant. So the authority of the COSHO to determine legally who can be on that job site is very troubling.
It seems extremely troubling, especially if there's proprietary information, then that could be gained by a third party walking through. Chief Bradley, this one size fits all, this is the consistent theme for OSHA. And this new rule that is impacting volunteer firefighters, apparently impacting more than 331,000 volunteer emergency responders. Can you explain why this proposed standard can apply? Like, what is it that's catching them into this new standard?
Well, thank you, Congressman. The inclusion of volunteers would come somewhere along the lines of compensation. Many receive benefits. Some volunteer chiefs are paid stipends, and OSHA considers significant compensation to establish an employee-employee relationship. The advent of the additional standards, one size fits all, NFPA standards are based on 0 to 100 in the fire service, so they include everything a fire department may be exposed to. So that one size fits all has worked in the fire service because NFPA allows an authority having jurisdiction. If you remove that authority having jurisdiction and the standard is adopted by reference by OSHA, then there is no local decision on what portions of the standard apply. So in that light, one size fits all just doesn't work for the fire service.
As we've heard this hearing, OSHA has this tendency to overreach. One question I have for you that came up recently in this hearing that we had from our former Secret Service Director, Kim Cheadle, who resigned, thankfully, after our Oversight Committee hearing. But at one point she had said that because of OSHA regulations, the sloped roof, that there's a safety factor that could be considered there, that we wouldn't want to put somebody on a sloped roof. Chief Bradley, are you aware of any safety rules that would prohibit your firefighters from trying to save lives on a sloped roof?
Most firefighters receive training or education in terms of ladder use. The ice on the roof the fire service is typically equipped with what's known as roof ladders with hooks. There are conditions that would make roof access difficult, but I'm not aware of any condition other than the roof being weakened by fire that would prevent firefighters from getting on a roof.
Thank you. My time has expired.
I now recognize the ranking member of the full committee, Mr. Scott, for 5 minutes.
Thank you, Mr. Chairman. Mr. Brab, good to see you again. Did you have a comment on the idea of exempting volunteer firefighters from OSHA?
I think Chief Bradley's made some very good points. I think there are definitely questions about feasibility. That being said, let me just say this. If my daughter or son was a firefighter, I would want to ensure that they had the maximum protections that every other firefighter or emergency responder has. That being said, again, I think Chief Bradley made some good points, and I think, luckily, happily, OSHA has a extremely robust public comment period. There are written comments going on. There will be probably days or maybe even weeks of hearings followed by post-hearing comments. OSHA will take in all that information, and if the evidence is strong that it's not feasible for volunteer firefighters, I'm sure OSHA will address that either by exempting them or perhaps reducing the requirement. So I think the process is still going on, and I think we need to trust the process to determine the best outcome.
Thank you. Comments have been made about how long it takes to get a final rule. You were around when we finally got a rule on beryllium after a long period of time. What are California and Washington State doing that is quicker than OSHA? I think, during my time at OSHA, there was nothing more frustrating than having to delay standards mainly because of lack of funding there. And I certainly sympathize and agree with much of what Mr. Gerstenberger talked about the frustrations involved in the delay of the tree care standards and many other standards. Washington and California have different systems. Instead of having all of the studies that need to go into a standard that OSHA has to do, all the different analyses and review that take years and again sometimes decades. They have basically standards boards that look at the evidence and determine what the best standard would be. And they also have a public input process, obviously, with hearings and input. But they have developed systems that work much faster and much more effectively, which is why you already see heat standards in California and Washington, workplace violence standards and ergonomic standards in California. A lot of different standards that OSHA just has not had the resources to be able to complete.
Why can't OSHA adopt some of those processes?
Why can't they adopt them?
Why can't OSHA do that?
Well, OSHA has a number of requirements. I mean, the law obviously requires that the standards be economically and technologically feasible. They have the SBREFA process, which has to do a pre-review of small business concerns. There are a number of executive orders coming out of the White House and other laws and court decisions that have been issued that lengthen the process for federal OSHA. And I can't help mentioning again the budget. OSHA's budget was always small for regulations. The Trump administration cut that budget by 10%, and it was only gotten back up to where it was during the Obama administration last year. So OSHA is really starved for funds, making it really unable to go through the kind of processes that are required by the law and to get anything out on a timely basis.
Making regulations is just one thing they do. They investigate, they visit work sites. With the budget they get, how often can they visit a work site? I've been talking about how underfunded the regulatory program is, but also the enforcement program is extremely underfunded. And I will mention also the majority proposal this year would cut enforcement substantially. I mean, right now it would take OSHA, if it were to inspect every workplace in the country just once, about 186 years. So what that means is that unless a worker is killed on the job or seriously injured or there's a worker complaint, any given employer is very unlikely to ever see an OSHA inspector. We had this legislation pending on violence prevention in healthcare settings. What could OSHA do to reduce violence for healthcare workers?
Yeah, violence against healthcare and social service workers has long been a problem. They're frequently assaulted, especially in emergency rooms. Obviously, social workers, mental health workers work in very dangerous environments with patients and clients who have a history of violence. OSHA has issued guidance since the late 1990s. It was updated in 2012, that have very effectively addressed the problem of workplace violence and would recommend at this point that employers have some kind of workplace violence program, that they implement a number of measures to reduce the chances of violence. For social workers, maybe buddy systems when they're out, communications, refashioning the workplace, having metal detectors in emergency rooms, that type of thing. So there are measures that OSHA can take, and in fact, as I mentioned, this body, the Congress, the House of Representatives, has passed legislation twice that would require OSHA to issue this standard.
The chair of the full committee, Dr. Fox, is recognized for 5 minutes.
Thank you, Mr. Chairman, and thanks to our witnesses for being here today. Chief Bradley, 23 of my House Republican colleagues and I sent a letter to DOL urging withdrawal of OSHA's emergency response proposed rule. The letter points out that the proposed rule would exacerbate existing retention and recruitment challenges for qualified emergency responders, especially volunteers. What are some of the reasons that volunteer fire departments are struggling to recruit volunteer firefighters, and how will the proposed emergency response standard impact volunteer firefighter shortages?
Thank you, Chairwoman Fox, and thank you and your colleagues for that letter and bringing this issue forward. Retention and recruitment has been an issue in the volunteer fire service for several years, and there are a lot of reasons. One being people work outside their community now. People are leaving rural communities for jobs in suburban areas. But the biggest reason we hear in the volunteer fire service is the commitment, the time that an individual has to put in. What would exacerbate this that situation with this rule is the added time and that an individual would have to seek just for education. I was a volunteer fire chief in your state in Mebane for 7 years, and I cannot imagine accepting the job of a volunteer fire chief with the administrative responsibilities that are going to come with this rule, this proposed rule.
Thank you so much, Chief. Ms. Watson, the final walk-around rule dramatically lowers the qualification standards for individuals who are allowed to participate in an OSHA job site inspection as a third-party representative. These third-party representatives could be someone such as a union organizer or community activist without safety experience. OSHA claims this rule will somehow improve worker safety and health. Could you discuss whether the walk-around rule will improve worker safety and health?
Thank you, Chairwoman. No, I don't believe that by relaxing the standards of who can accompany the compliance safety and health officer will actually achieve OSHA's goal. If their goal is to improve the inspection process and the representative of the workers, then they should work within the confines of what they already have. By allowing just anyone to come on the job site, that person might not be familiar with the job site, they might not be familiar with the employees, and what the requirements would be. I don't think it lends anything to the process of improving worker safety, certainly, and improving worker representation. There's other ways around that.
Yeah, it's just common sense. I've gone to a lot of job sites, a lot of companies, and done walk-arounds, and you have to be so careful what you do, and the more people you have, the more dangerous it is. There's no question about it. Mr. Gerstenberger, you mentioned in your written testimony that arborists rely on several methods for accessing a tree for trimming or removal, including using cranes. Can you explain how OSHA's current enforcement approach might deter companies from using cranes, even when it's determined to be the safest method for accessing a tree?
Thank you, Dr. Fox. I will have to start with the underlying standard governing this situation. 1910-180 has a clause in it that says workers shall not be hoisted or swung using a crane. Currently, OSHA allows, through its enforcement memoranda, the employer to mount an affirmative defense to using a crane to hoist a worker in a tree when they determine it's the safest or only feasible way to access that tree and perform the work. However, mounting an affirmative defense means that the employer in question must first be cited. So that in and of itself is an onerous and laborious and time-consuming process. I don't know an employer in my association who would shy away from using a crane to put a worker into a tree, because it has proven since 1968 to be a very safe practice. And considering the alternatives of climbing dead trees, decayed trees, or having to ascend over multiple branches to access the top of a tree, or place an aerial lift or compact lift directly under a tree to access a very tall tree, the idea of a rated anchor on a crane that's capable of supporting tons seems very, very desirable. And so my members regularly adopt that practice.
Again, it makes sense. It's just common sense. And as someone who's had a lot of tree work on tall trees done in our yard, and we just look around here and see how they use cranes for many different things, it just makes sense to be able to do that. Thank you very much, Mr. Chairman, and thanks to our witnesses again. I yield back.
The representative from Illinois, Ms. Miller, is recognized for 5 minutes.
Thank you, Mr. Chairman. I just have a real quick question, and for Mr. Barr.
This is Mr. Owen. Sorry, if you, I think we have to recognize Ms. Miller first because you're waving on. So we'll go to Ms. Miller from Illinois, and then Mr. Owens from Utah. My apologies.
Thank you, Chairman. Ms. Watson, as you know, the OSHA Vaccine Emergency Temporary Standard was struck down by the Supreme Court because it was deemed unconstitutional. Following the ruling, OSHA Administrator Douglas Parker told Reuters, quote, The ruling was unfortunate, but it's not stopping us from pressing employers to take adaptive measures to keep things in place. Ms. Watson, do you think OSHA has the power to circumvent the Supreme Court's decision on vaccine mandates, or does OSHA have to abide by the Supreme Court's ruling?
Thank you, Representative. I think that OSHA, if they're prudent, will follow what the Supreme Court said. If Congress gives OSHA the authority to change that, that's why we have the three branches of government. I think that OSHA is looking forward certainly at an infectious disease standard, probably targeted at something like that. The concern is compelling employees to receive vaccinations when there are a host of reasons why they shouldn't. Or don't want to, or maybe don't need to. And so for a government agency to tell employers that they have to vaccinate their employees is extremely problematic. And I think that if OSHA moves forward with anything like that, it should do so with caution and a thorough legal analysis. But right now, no, I don't think that they have the authority to do that.
Let's hope OSHA abides by the court's rulings. We've all heard very many sad stories of people that had their personal reasons to not want to take the vaccine, and they were fired or they took it under duress. And I don't want it ever to happen again. Ms. Watson, OSHA has ignored concerns from farmers about issuing a one-size-fits-all heat rule. The proposed standard mandates rest breaks of 15 minutes at least every 2 hours once it reaches the high heat trigger. How do you think this will impact the agriculture industry and other industries too?
So the high heat trigger kicks in at 90 degrees Fahrenheit, for those who haven't heard all of that. The initial heat trigger is 80 degrees Fahrenheit, but the mandatory rest breaks, as you say, do kick in at 90 degrees or higher. I think the impact there is that might affect their processes in how they can do things. There might be circumstances where employers have employees doing a task, they might not be able to take that break. OSHA recognized in the proposed rule in the preamble that examples such as pouring concrete, where you have to complete that pour, you can't just stop every 2 hours unless that is, if you're in the process of pouring the concrete, because otherwise it's ruined. The issue there for the agricultural workers, those are some of the most vulnerable because of their work circumstances. So I think it's important for employers always to provide water, rest, shade, and provide rest breaks as needed. Sometimes making it a mandatory thing doesn't work. Even if you try and stagger your employees on when they're going to take their mandatory 2 hours, that might leave your workers shorthanded on a particular project. I like the idea, and I think it's really worthwhile to encourage employers to tell their employees you can take rest breaks as needed. That way they can help self-moderate.
Thank you, and I yield back to Chairman Kiley.
The representative from Utah, Mr. Owens, is recognized for 5 minutes.
Thank you so much. Mr. Barrick, I just have a real quick question. I looked at your background. You've been government worker for 46 years. Is that correct in that range? Okay. Have you ever run a business?
Have I ever owned a business?
Yes.
No, I have not owned a business.
The employees that you have, are they coming from the industries that you oversee? You have people, for instance, in the tree service industry. Anybody like that within OSHA that are hired there? Or are they also government workers, pretty much?
I'm sorry. Is there anybody in OSHA that's worked in the tree? I'm sorry.
Yeah. I'm trying to understand. What I'm trying to understand is the experience that you have when you oversee the broad spectrum of businesses you oversee. And my concern is, I think there's a premise. It starts off that the employee cares more about that the OSHA employees care more about business, the employees out in the field, than the owners do, the folks in this area. Am I correct on that? Is that something that you kind of think you have to protect employees from the employers?
I think most employers want to do the right things and protect their employees. I have no doubt about that, and most of the employers I've met want to. But there are a lot of employers who don't. I mean, who cut corners on safety and workers'
it sounds like the rules seems like they're tainted toward those who don't care. And I guess my concern is I look at just common sense of you have a comment period that people have to go through. My experience is very simply this: when you have a government employer, a government employee that seems to know it all already, and you give them the power to do whatever they want to do, the comment period doesn't really mean very much. What is already preordained is going to come out. This is the way my experience has been. Would it be helpful that maybe if you're overseeing these industries, that somebody who understands the industry is represented within the government process?
Yes. Let me say two things about that. One is, again, OSHA's got a very small budget. They can only have so many staff there. They can't have staff that's an expert in every area. But what OSHA does to address that is they use a lot of their regulatory funding to hire consultants that do have that kind of experience.
These consultants are not, and here's another problem. First of all, I always hear about the lack of money, and I'll be honest with you, entrepreneurs are very happy when OSHA doesn't have a lot of money, because what happens is you're putting people out of business. The things that you're doing, even for someone as a lay person, makes no sense unless you're going in with the premise that these are bad guys. They need to be stopped. They need to be halted. You mentioned, is your son a fireman? You mentioned, I don't know if your son is a fireman or not. You mentioned earlier that if your son was a fireman.
Yeah, right. I didn't say he is. I was saying if any of my children were fire responders, I would want them to have.
With that being said, would you agree that the fire chief, if your son was a fireman, the fire chief would care more about your son than some stranger in D.C. who has no idea who your son is?
I think that's kind of a red herring.
No, it's not a red herring.
OSHA has.
Okay, I'll reclaim my time.
No, but OSHA has a robust.
I just have a few minutes. That is what's called common sense. Is someone who is in the game, who oversees people that they know, they're employing people that they want to keep, retain. Do they care more about some bureaucrat who has no idea but has a lot of good theories? And that's the problem with OSHA, is a lot of good theories, but it runs people out of business. We're concerned about rural communities holding on to fire services, but it doesn't seem like the DC people really understand that or care about it, because you're not listening to the concerns. You put together a comment period, and you're going to do what you're going to do. We all understand how that works. So I just real quickly, Chief Bradley, if you could have some suggestions or ideas about how to approach this one-size-fits-all for each emergency services. Could you, within the next 30 seconds, kind of explain what that would look like? If you can kind of give an idea or support or suggestions of how this should be approached.
Yes, I think that the standards should be written prescriptive to the needs of injury prevention rather than adopting by reference industry standards that cover a lot of things that are not specific to injuries. Also, I think involvement of the fire service leadership in writing those rules would be beneficial.
Okay. Well, thank you. I appreciate all your feedback. I'll get back.
The representative from Michigan, Mr. Wahlberg, is recognized for 5 minutes. Oh, the other representative from Michigan, Ms. Stevens, is recognized for 5 minutes.
Thank you, Mr. Chair, and thank you to our witnesses. Mr. Barber, we just completely appreciate what you're doing at the Department of Labor as Deputy Assistant Secretary for OSHA. And coming out of the COVID time period in particular, where your department was very stressed, and this very subcommittee spent a lot of time with you, the American people know all the more the importance of the work that you and your very large workforce, maybe it could be larger, does to keep workers safe, maintain standards, and work alongside the businesses of this country. So I wanted to ask about heat stress and what the rule actually says rather than just the rhetoric surrounding it. So OSHA's proposed rule mandates employers plan to monitor employees for heat stress and provide resources like shade and portable water with heat indexes that reach up to 90 degrees. Is that correct?
Yeah, I think that there are two different triggers. I think, one is in the 80s and one is at 90, yeah.
Okay, and then the rule would mandate employers have to provide 15-minute breaks every 2 hours at a 90-degree heat index?
Correct, yeah.
Okay, and then in your view, do these provisions in the rule constitute a complete work stoppage or an undue regulatory burden that seriously impacts productivity, and why or why not?
Yeah, I mean, break times are needed, obviously, to protect workers' health. And we all know also, and I think Dr. Adams mentioned it in her opening statement, that heat takes a terrible toll on worker productivity. So anytime you can help workers, especially through rest breaks, you're going to increase their productivity. We also know that if workers aren't given the rest breaks, they kind of take their own breaks. They'll take some time to wipe themselves off or catch their breath or rest anyway. So they're already taking these breaks, and it's science has found that it's a lot more efficient just to require 15-minute breaks every once in a while. It will not only protect workers, but it'll also increase productivity.
Yeah, and my father is an independent business owner, 79 years old, still doing landscaping. I got to check in on him, make sure he's drinking his water, sitting in the shade. He just loves being out there, loves doing the design and the implementation. But can you just also explain how third-party reviewers present at OSHA inspector walkarounds can help improve worker safety?
Yeah, thank you for that question. I want to say a couple things about walk-around. First of all, OSHA's new regulation that allows third-party walk-arounds is nothing new. OSHA has always allowed third-party walk-around representatives. In the original regulation, it said, it gave examples such as a safety expert or an industrial hygienist, but it was never exclusive. And this rule actually put a little bit more requirements into what that walk-around representative qualifications needed to have. So it's nothing new. It's never been a problem before. And it is very helpful for workers, and it does protect workers' health and safety. We know that if there isn't a walk-around representative and OSHA inspectors are then supposed to just talk to a number of employees, that employees are often intimidated. They often get punished, or they feel they will be punished for talking to OSHA inspectors.
Yeah. And would it be reasonable to assume that union representatives with their years of experience negotiating for increased safety standards and familiarity with a wider breadth of facilities be helpful to inspection as stated in the rule?
Yeah, either in union sites or non-union sites, having experts in there that the employees trust and that may know a lot more about that specific workplace possibly than the OSHA inspectors do, that may be able to speak the language that the employees speak. All of that can help the employees safeguard their health and safety. It's important. It's one of the most important things that Congress put in the Occupational Safety and Health Act was to allow walk-around representatives.
Yeah, and just one more to squeeze in, because many of my Republican colleagues believe allowing union third parties on inspections would lead to surreptitious organizing campaigns during walkarounds. In your view, would it be possible for a union official to be able to conduct this typically months to years long effort to organize over the course of a few hours during an inspection on the walkaround?
I'm sorry, what the question?
So I'm asking you to shut down that they're saying that we're sending inspectors to organize the unions. They're just inspecting. They're not doing years-long organizing campaigns while they're inspecting for health and safety over a few hours.
Right, and
but God forbid we keep people safe. There
is language in the regulation and in OSHA's field operations manual that gives inspectors the authority to deny the right of accompaniment under this section to any person whose conduct interferes with a fair and orderly inspection. So anything that the COSHO decides is not directly related to the inspection, he or she is perfectly able to kick that person out of the workplace, and they do that. They will do that.
Yeah.
They're equipped to do that. They can do that. They're allowed to do that. This is not a real problem.
Yeah, it's a job site. Thanks. I yield back. Thank you, Mr. Chair.
The representative from Connecticut, Mr. Courtney, is recognized for 5 minutes.
Thank you, Mr. Chair, and thank you to the panel for being here today on such an important topic. I appreciate the opportunity getting waved in as not a sitting member of this subcommittee. I used to be on this subcommittee, as Mr. Barra remembers. And I did want to just, as long as we're talking about OSHA priorities, and I think Mr. Scott alluded to this earlier, is that, one of the I think most urgent issues before OSHA and Congress is the crisis that exists in our healthcare sector. Again, 2016, we had a GAO report which showed that people who work in hospitals, nursing homes, EMTs, ride in ambulances are subject to workplace violence at a rate of 5 times greater than any other sector in the U.S. economy. We had a horrible tragedy in my district in eastern Connecticut last year where a home health nurse went into a home. Again, it was an individual that was on the sex offender list, and she never emerged after it. 56 years old, large family, heart of gold. And unfortunately, that's not a rare instance. The numbers that GAO produced in terms of kicking, hitting, spitting, and actual violence with weapons is something that happens far too often in emergency rooms, psychiatric hospitals, and again, the folks who ride the ambulances, particularly on overdose situations where, again, they are subject to workplace violence. So, Mr. Barab, you know there's a pending rule that has been slowly, excruciatingly slowly moving forward, which would put in a workplace violence prevention standard. It has been scrubbed in terms of the financial cost. It is a fraction, tiny fraction of the overhead of healthcare institutions. Again, and this would be aimed at really just putting into place common sense preventative measures, which have been shown to work in other parts of the country. OSHA has set up voluntary guidelines to make that, to at least give people best practices out there to stop this epidemic of harm and violence. But again, we're still sort of just moving along at a snail's pace. We have legislation to accelerate that process. There's precedent for it when the AIDS crisis hit. And again, people were subject to bloodborne pathogens. And this happened again in first responders as much as any other population out there. Congress forced the process to move forward to put into place the standards that today include gloves, disposable needles, I mean, all the things that have worked to prevent the spread of AIDS. So again, can you, again, just talk about, again, this priority, which is in the pipeline, but, just inching along, and how this is a way Congress can actually save the lives of nurses, emergency room physicians, again, the healthcare providers, 15 million strong in this country, who, again, are subject to an unacceptable level of violence that is burning out staff and making it harder to recruit people into the field.
Yeah, thank you for that question, Mr. Courtney, and I commend you for your leadership on this issue. I have been working on the issue of workplace violence for 40 years. I used to work for a union that represented healthcare workers and social service workers. It's always been a terrible problem. We had a struggle to get OSHA to try to address it, which they finally did in the 1990s. And as you say, they've been making frustratingly slow progress on a workplace violence standard, despite the fact, again, that this chamber has passed legislation twice on a bipartisan basis to force OSHA to issue that standard much more quickly. OSHA standards, this standard and other standards, are not just based on somebody sitting in a little office across the mall. They are based on what is going on, what the best employers are now doing to prevent workplace violence in their workplaces. These measures that OSHA will require work. They're feasible. They save lives, and the sooner OSHA can get that standard out, the more lives that will be saved.
Thank you. And again, as you point out, this is something that is in place in some healthcare systems, and it's showing great results. And we're talking about simple things like flagging high-risk individuals. The case that happened in my district, someone being on a sex offender list, she never should have been going into that home alone. Mm-hmm. And, having, again, that sort of flagging system and a communication system, and also learning how to sort of address and mitigate and respond and control violence and aggressive behavior works in terms of saving lives. So again, I thank you for clarifying that issue, and hopefully we'll pass the bill. Mr. Bacon, Republican, is the lead sponsor in this Congress. It would pass. There's just no question about it, and we could actually do something to help the caregivers of our nation. I yield back.
Thank you. The gentleman's time has expired, and I recognize myself for my 5 minutes of questioning, and thanks to the panel for being here. Chief Bradley, having the privilege of representing a good number of rural communities who rely on volunteers for their fire department and do what's necessary to make sure that those departments are put together well. They already operate on limited budgets, as you know, and face significant funding challenges. My question is, how would the new mandates on volunteer departments included in the emergency response proposed rule exacerbate these challenges?
Well, the proposed rule, thank you, Mr. Chairman, the proposed rule adopts by reference NFPA standards that have long been considered in the fire service voluntary consensus standards. In many of those standards, they apply rules or standards such as equipment replacement in a certain duration, training. The increase in the cost of replacement for equipment, the increase in responsibility for hiring certified technicians to inspect trucks every so often. Those are things that are not done consistently and not affordable for many rural fire departments. And in addition to that, just the issue that the standard does not define specifically volunteer issues, doesn't allow for the variation for local jurisdictions, for the authority having jurisdiction to determine the applicability. All these things would increase the cost to the rural community fire department that doesn't have the money now.
Yeah. Having a late father-in-law who was a volunteer firefighter in his retirement years told me numerous testimonies of citizens who said, we'd like you to be as best trained as possible, best resources possible, but the most important thing is that you show up. And sometimes we get in the way of that. Thanks for your service. Mr. Gerstenberger, during the Trump administration, OSHA convened a Small Business Regulatory Enforcement Act, SBREFA, panel to hear feedback from small entities on potential tree care standard. Can you talk about the panel's findings in the small business report and whether it recommended that OSHA move forward with a tree care standard?
I would summarize the SBREFA process, and thank you for that question, in our industry with 3 points. First, the insight was gained that the vast majority of employers in our industry are indeed small business as defined by OSHA and SBA. So these are small and tight-knit, often family-operated businesses, caring deeply for each of their employees, personal relationships with each of their employees. Second, it was gratifying, I guess I could say, to say that there was overwhelming support for the idea among these businesses for a separate standard that would govern them. There was very little dissent among that group that indeed a standard would be welcomed and could be very advantageous for the industry to help perhaps the poor practitioners in our industry be a little safer and better at what they did. Third point that I think came out of that process was that looking at the scope and application of this standard was going to be very important. That we wouldn't want to, in this process, inadvertently drag in other groups, other industry groups that shouldn't be regulated by this standard, that it should apply to those employers who truly faced the hazards associated with tree work. Some of the more profound hazards, the struck-by hazards, the falling hazards associated with working on large trees. So focusing on the scope and application of a proposed standard would be very important in ensuring its success.
Unique industry.
Yes.
In your written testimony, it notes that some state plans have adopted regulations specific to the tree care industry, and there is a voluntary consensus standard in place for the industry. I gather OSHA does not look to those state plan regulations, but instead uses other OSHA regulations that are not specific to your industry. How would a federal OSHA standard improve the safety of the tree care industry?
So currently, right now, through an enforcement memorandum, OSHA COSHOs are instructed to obviously apply the existing OSHA standards where they can be applied, but in many, many instances, the OSHA COSHO has to invoke the general duty clause of the OSHA Act, and then go on to cite specific passages in our voluntary consensus standard as what that employer should have known and should have done. That is problematic for the COSHO because in bringing a citation under the general duty clause is a lot more work. It also doesn't provide any upfront guidance to the employer out there because in a general duty citation, it's a smoking gun situation where the COSHA goes into a work site, say there has been an accident, and there's evidence of what happened, and then the COSHA can look at the voluntary consensus standard and says, aha, that is what that company should have done. But there's nothing in existing standards in OSHA to proactively guide that employer or guide that COSHA as to what appropriate practices were. So to summarize, having some of that language from our standard codified in standard would provide guidance not only to the COSHA, but also to the smaller employers, particularly the smaller employees, as to best practices.
Thank you. Thank you. My time is well over expired. But I guess that's the joy of sitting in the chair, the last point. So I'd like to thank our witnesses again for taking the time to join us today. Without objection, there being no further business, the subcommittee stands adjourned.